Okay, so obviously we're getting differing opinions from the drafters of the legislation and the judicial bench right now. The reason why, and I'm going to try to explain it, and I'm not saying that I'm not arguing or presenting my own opinion here. I'm simply trying to explain the legal arguments that are going on because a lot of people are saying things online that aren't true. Okay, so one of the biggest issues and why the judiciary is saying this law does not apply retroactively is because ARS 1244 says, and it's very short, no statute is retroactive unless expressly declared therein. That is included in the Arizona revised statutes. So now we've got to also look at what, in addition to our ARS statutes say, we've got to look at the existing case law on the issue because case law is controlling on these things until you have new case law that says otherwise. Now, there is some case law in Arizona dating back to 1935 that says statutes are presumed to operate prospectively, forward-looking, not retroactively, which is what we need if we want this law to apply to existing cases. Okay, now I'm going to read from a Supreme Court case, highest court in the land, that came out in 2025. And if this or when this legislation goes up on appeal, I believe that this case will be heavily cited. The presumption against retroactive legislation is deeply rooted in our jurisprudence and embodies a legal doctrine centuries older than our republic. For that reason, the principle that the legal effect of conduct should be ordinarily assessed under the law that existed when the conduct took place has timeless and universal appeal. Okay, so that's really important. Conduct should ordinarily be assessed under the law that existed when the conduct took place. Has timeless and universal appeal. So that means what law was in effect at the time that the DV took place? And what law was in effect at the time that your petition was filed? Okay, then they go on to cite that this anti-retroactivity principle finds expression in several provisions of our Constitution. So they then go on to cite the United States Constitution. Okay, so now we're talking about constitutional rights that say retroactive statutes raise particular concerns with respect to the legislator's ability to sweep away settled expectations suddenly and without individualized consideration. I'm not making an argument against the application that many people want. I am simply trying to explain how difficult this argument is going to be to overcome. I'm also trying to clear up the unfortunate misinformation that's going around, because just because a legislator or sponsor of a bill is saying one thing and saying this is what we intended when we made that legislation, it is not the only factor that the court is going to look at. And unfortunately, we also have to look at existing case law. We also have to look at our existing statutes on the books. So this is why this is so complicated. If I think about that from a non-legal perspective and a common sense perspective, no duh, anyone should know that DV actions are going to result in consequences, right? But when we look at it from a legal perspective and from the perspective that the court must follow, these are the arguments that we have to consider. This case also refers to ARS 1244. When the legislator expressly declares that a statute is retroactive, the presumption against retroactivity does not apply. It then cites another case which states statutes must contain an express statement of retroactive intent before retroactive application may occur. Again, this is our existing case law from the highest court in the state. So if we are to overcome that and say, oh, it applies even without the retroactive language in there, I don't know what legal argument someone is going to make for that. There are very intelligent and capable appellate attorneys that will take this up, but this is going to be difficult. Attorneys and legal minds will disagree on the simple application of language, but this is the battle that exists before us right now. There is a clear benefit in requiring the legislator to provide an express statement of retroactive intent. Doing so helps ensure that the legislator has weighed the benefits of a statute applying retroactively against any potential unfairness or negative effect on private rights. Parental rights are a private constitutional right. So again, very high burden to pass here. Interestingly, even so, it is not necessary that the legislator use the expression, "This statute shall apply retroactively," or any similar one to accomplish the purpose of retroactivity. Any language that shows a legislative purpose to bring about this result is sufficient. Declarations of intent may be helpful in interpretation, but the text of a measure must be considered first and foremost. That might save the day on this. We don't have to use the exact words retroactive, but legislative purpose is going to be a big one. I think it's clear that the legislative purpose here was that it would be effective immediately, but they're going to need to argue now about whether that purpose also implied retroactivity. We know that that's what we're being told, right? But the court ultimately, after an appeal, is going to have to resolve this. And unfortunately, that process is probably going to take years, which means that for now, judges are going to continue to look at the existing law and apply it based on their own legal interpretations and their own legal opinions. This is very messy. This is very complicated. This means that people will end up with different results until this is resolved.